We've gotten into the details of discovery. So let's think first about the limitations that the rules set on how far discovery can go, and then think about other ways that the court manages and crafts and shapes discovery. So first of all, let's think about what it means for discovery to be proportional. So you'll remember material is discoverable if it is not privileged, relevant, and proportional to the needs of the case. So some things that the court is supposed to consider is how important are the issues in the action, and how important are the things that discovery is being sought on to resolving the litigation. What's the monetary value of the lawsuit, and what resources does each party have, who has access to the information and other easier ways of getting it, and perhaps primarily there's just a weighing exercise of deciding whether the burden, expense, or other problematic issues with the discovery is worth the benefits for this lawsuit and to some extent for public interest. So this is an extremely mushy test. It's not really a test, it's just considerations that the court should keep in mind. And the proportionality requirement has really only been around for a few years, and so there isn't a huge amount of case law setting forth a clear test for how courts should consider this. So this is one of the ways in which discovery is really, really discretionary and really hinges a lot on your communication with the court and your explanations for your requests or oppositions to discovery. There are some clearer rules about limiting discovery, but again, these all hinge on highly discretionary judgments. So the court is must limit discovery that is unreasonably cumulative or duplicative, easier to get elsewhere, the product of bad faith delay. But again, the court has to determine that these things are the case, and only then is it obliged to limit the discovery. And obviously, if it's outside the scope of Rule 26, then it's not discoverable to begin with. But as we saw with Faval last time, to some extent, whether it is determined to be outside the scope of Rule 26 is going to depend on the court's understanding of what issues are relevant to parties' claims and defenses. The court also has an explicitly discretionary role in 26C, which says that the court may limit discovery through protective order to protect a party from annoyance, embarrassment, oppression, or undue burden or expense. And we saw that in Rengifo, I think, where the material that the defendant was requesting, the plaintiff's immigration status information, was probably relevant to some extent, at least in a broad sense. Perhaps one could make that argument. At any rate, the court didn't say it's absolutely irrelevant, but it certainly seemed to be more likely to cause embarrassment and oppression, in other words, to encourage the person not to pursue their rights, than it was likely to really give the defendant really usable, useful information that would really come into play in the litigation. So let's think now, I should have done this in a one-by-one, but just try to keep your eyes on the top here while I'm talking. So how does the sequence of a discovery dispute happen? So we've read a bunch of results of discovery disputes, just so you understand how they get there. Here's what happens. So party A requests production of something, right? Anger management documentation, immigration status information, whatever it is. Party B doesn't comply. And at this point, Party B actually, they can say, I absolutely refuse, this is absurd, you're a jerk for even requesting this. Or they can just sit on it and just not respond, right? One way or another, they fail to produce. Party A at some point has to decide that it is important enough to them to get this material that they make a motion to compel. Sometimes, I'd say most of the time, these kind of disputes are handled actually without a motion to compel, just through phone calls. So party B calls up and says, "You've got to be kidding me. I'm not giving you, the full medical history up to the immunization records of elementary school for my client. Get out of here." And then they negotiate. Party A says, all right, I don't want the immunization records, but what about the last year of therapy records since you're making an emotional distress claim? Something like that. So usually these things are actually settled through negotiation between the parties, and the court is actually never involved, which is one reason why there's so little case law on this, why it's kind of a less rule-bound area, because a lot of this happens out of sight of any legal personnel. Okay, but let's say party A decides that it does matter and makes a motion to compel. It addresses the court. That's a motion to the court saying, Your Honor, please get party B to disgorge this information that I'm requesting. Party B then responds to the motion to compel, and they basically have two choices. Either they oppose the motion to compel, filing a brief to that effect with the court, or they can also just comply with the discovery if they actually don't want to fight it. And then there's the motion to compel is moot. There's no reason to fight about it. A gets their discovery. Assuming party B files an opposition to the motion to compel, the court then rules on those motions after usually oral argument. And there's a number of choices that it has. So it can compel the discovery to the full extent. It can also prohibit or refuse to enforce, refuse to compel the discovery that A requested to the full extent altogether. But as we saw in the very first discovery case that we read, TGR, way back in the first week, it can also modify the request to make it more reasonable, proportional, relevant, etc. It can say, you're asking for 40 years of records. That seems really excessive, but I can see how this is relevant. Why don't we say you can request 1 year of records, or whatever, right, depending on what the case is. And finally, the court can also compel some or all of the discovery to be produced, but also issue a protective order. So we talked about protective orders a little bit in class. The main thing to know about them is that the court basically does what it wants. It can craft protective orders to reflect what the court decides is the just outcome. And just to give you some examples of how that typically goes, the court might say, I'll allow you discovery into this topic, but not that topic, or into this area of documentation, but not that area. Or it might say there's a protective order prohibiting discovery into more than 1 year of medical records, whatever the court thinks is the right approach. You might also have a protective order that limits the sharing of the information. So I'll give you discovery into everything you're interested in, or maybe just part of what you're interested in, but the lawyers cannot reveal it beyond this litigation. So only lawyers and parties can see the materials, or even attorney's eyes only. Only the lawyers can see. And even the parties sometimes will not be allowed to see the material that's produced. But in general, this is really one of those areas where, again, the court decides and the court rules. So whatever the judge thinks is just, reasonable, and proportional, they can craft the protective order to reflect that. We also discussed the way that some communications are completely off limits to discovery. That's called privilege. And those are not discoverable even if they are relevant. But it's important to note the boundaries of privilege. First of all, only the communication is privileged, not the underlying facts. So saying, did you discuss this with your lawyer, is covered by the attorney-client privilege. But saying, did you do this thing that people say you did, that is not covered by attorney-client privilege. Similarly, or relatedly, communications are only privileged if the person is acting within their relevant role. So did you discuss this with your friend who happens to be an attorney? That's not covered by attorney-client privilege. Did you discuss this with your brother while your attorney happened to be in the room? Also not covered by attorney-client privilege. Did you discuss it with your friend who happens to be an attorney and whom you have retained as your attorney for this matter? That is covered by attorney-client privilege. So it's when you're consulting your attorney in a legal capacity, that's when attorney-client privilege kicks in. The other really important thing, especially for lawyers, to realize about privilege is that privilege can be waived. Revealing the information, revealing the communication to a third party waives the invocation of the privilege, as does putting the information at issue in the case. And once you've waived, you no longer have a claim of privilege to it. One way to think about this is that it's the party who owns the privilege. So the party has no obligation to maintain the privilege. If they want to waive it, they can waive it, and they haven't breached any obligation. You already kind of know this because it's the party who decides what claims to make, with the lawyer's advice, one hopes, but the party decides what claims to make in the complaint, for instance, and so they can waive their doctor-patient privilege, for instance, by putting a medical issue at issue in the litigation. So the party has no obligation to maintain privilege, but once it waives privilege, it can't take it back. The attorney, on the contrary, and the doctor, has an obligation to the party to maintain the privilege. So it is very important for us to avoid accidental waiver because we've not only potentially weakened our case, but we've also breached our obligation to our client. One other thing we discussed is something that's not quite privileged, but not quite not privileged, trial preparation material. So under Hickman, and now under the rules that have incorporated Hickman, material prepared for litigation is generally speaking not discoverable, despite not being privileged, but it's protected from discovery unless certain exceptions apply. So if the person seeking discovery has a substantial need for the information and can't address that need without undue hardship. So for instance, if the material is no longer available, if the boat sank or the witness moved out of the country and can't be located, then some trial preparation material can be discoverable. But the attorney's mental impressions, so ideas, legal theories, opinions, etc., are not discoverable, even under those circumstances. We also discussed expert witnesses, so people hired in preparation for litigation to help with factual considerations in the case. So if you're going to use an expert witness and present them at trial, that's something that needs to be disclosed in the required disclosure. But a person who is hired for litigation who will not testify generally does not need to be disclosed as a required disclosure, and their product, their work product, like their report and opinions, need not be produced to the adversary unless, again, much like attorney work product, it is impracticable for the adversary to obtain facts or opinions on the topic without that expert's report. And just to emphasize something here, it's not that the adversary has a right to obtain the facts of your expert and the opinions of your expert. It's that they have a right to obtain facts and opinions on that topic somehow. So if they have an expert who can go and examine the boat that carried the bananas, then they have an opportunity to obtain facts and opinions from their expert on that topic. But if the boat has sunk and there's no way to find out about it, and they didn't dilly-dally, right? It's not their fault that they missed their chance to examine the materials. Then the court might say it's impracticable for them to obtain facts or opinions, and the expert's report may need to be produced to the adversary. Finally, we talked about spoliation, so the destruction of material that should be produced in discovery. So one thing to note about spoliation is that it is a party's obligation to preserve potentially discoverable stuff even before litigation starts, if litigation can reasonably be anticipated. So once you've had a dispute that seems likely to be the sort of dispute that people sue about, you are under an obligation to start preserving information. If the party negligently destroys information, then the court is supposed to take steps to cure the disadvantage that causes to the adversary, but not to punish the party, just to level the playing field, right? To erase that disadvantage as much as possible. If, however, a party is found by the court to have intentionally deprived its adversary of information that should be discoverable, the court can punish them and impose sanctions, for instance, by itself making a negative inference or instructing the jury to make a negative inference, or even by dismissing or issuing a default in the case. I do think that looking at Mueller v. Swift gives you an idea of, in general, how reluctant courts are to find that parties have intentionally deprived their adversary of material. I think the weight of the class in that discussion was that sure seemed like he meant to get rid of that recording, but the court is very cautious and does not want to make that finding absent some more sign of intent. At the same time, I think the remedy that it crafts to cure the prejudice of allowing the lawyers to ask questions about all of these devices which have somehow disappeared or been destroyed on the stand is a pretty good way of allowing the information to come out in a way that will likely cause the jury to make an adverse inference without actually instructing the jury to do that.